Good afternoon, everyone, and good morning to those of you on the West Coast. This is Josh Lee, and on behalf of PCI, I'd like to welcome you all to today's GovCon 101, 10 key FAR clauses that every government contractor should be aware of, joined by our expert instructor, David Gallacher. Before we begin, I do have a few housekeeping announcements and reminders. Those of you new to our GovCon 101, we do not take any questions until the end. You are more than welcome to submit questions through the questions tab throughout the session, but questions will not be answered until we conclude these slides. In addition to questions, if you are seeking credit for today, please make sure you are tuned in, listening closely, and participating in the polling questions at the conclusion of the slides as well. If you have any questions about credit or certificates, feel free to let me know. I am more than happy to assist with that. I welcome you all, and I will hand it over to David.
Thanks so much, Josh Lee. I appreciate it very much. So just a reminder, questions are welcome. We'll deal with all the questions at the end, but if you want to, type those in along the way, we'll get caught up with them here at the very end. But it is a pleasure to be here with you to talk about 10 key FAR clauses that every government contractor should be aware of. I'm mindful of the fact that title ends with a preposition, and some of you grammar purists out there may very well accuse me of a grammar crime, and I apologize, but I'll tell you the idea of 10 key FAR clauses about which every government contractor just sounded too much like a lawyer wrote it. So anyway, but go figure, a lawyer did write it. My name is David Gallacher. I am an attorney with the law firm Kutak in Washington, D.C., and I do nuts and bolts FAR, DFARS work, just about anything relating to federal procurement, and also some state and local as well, but especially federal procurement. I'm your guy. I've been practicing for about 20 years, and I have a specialty specifically in helping companies manage and understand their contract compliance. I do a fair bit of litigation, but most of my practice I would characterize as probably client counseling, where people call me up and they say, Dave, I've got a problem with delivery, or I've got a problem with my subcontract, or something along those lines. I'm there and I can try to help you through it. One of the great things I enjoy about my job, and for those of you that are in this kind of federal procurement space, is it's always changing. There's always a lot of evolution going on in this, because there's new policy, there's new world events, there's new legislation, right? And so I think it's good to come back and get a little bit of a refresher on this and remind ourselves, well, let's get back to basics. And hopefully these 10 key clauses that we're going to go through here today will be helpful. Now, as I put this together, when PCI approached me and said, could you do a top 10 clauses that every government contractor needs to be aware of, I said no, because I don't like top 10 lists. Like, I love my top 10 lists, but my top 10 lists are never the same as yours. I love talking to people about best movies of all time, and some will say The Godfather, and somebody will say Godfather 2, and somebody else will say, no, it's Casablanca, and then some nut job will say it's Logan's Run, and you're saying, what are you talking about? So the problem with these top 10 lists is that they're inherently a little bit arbitrary here. But I think oftentimes we can kind of reach consensus as to what is most important without necessarily offending whoever the nut job is who loves Logan's Run. And if it's you, well, we maybe share a little bit of a kinship. If you don't know who Logan's Run is, good for you. That means you are not steeped in nerddom and 70s sci-fi shows. So anyway, but what I put together for this here is, instead of doing top 10 clauses, these are 10 key clauses that, as I think about it and as I talk to clients, some of whom are very sophisticated government contractors, some of whom are not, these are 10 clauses that I think everybody should be aware of, because they hit you in one of three ways here. And so I've kind of put together three buckets to talk through. Some of these clauses, the first three, pose administrative risk to you. The next three pose supply chain risk, and then The last four pose compliance risk. Now, in truth, everything poses a little bit of compliance risk in your contract, right? Because if it's in your contract, there's an expectation that you're going to meet it. But some of these other ones relating to compliance, I think, have a little bit of a heightened obligation on that. So the administrative risk is relating to things that potentially can disrupt the orderly administration of or performance of your contract. So let's be aware of those. Supply chain risk. These are heightened obligations on you on what you can and cannot buy when doing work for the government. And this is a little bit of a new thing. The government used to kind of manage through its quality assurance programs, but increasingly, as national security concerns get ramped up, the government is increasingly using these thou shalt not type clauses relating to supply chains to try to make sure that the government systems are safe and secure. And we'll look at those here in a minute. And then, of course, compliance risks are those things that impose affirmative obligations. Now, there are I think there's more than 600 different clauses plus alternates that are built into the Federal Acquisition Regulation. And that doesn't even get us over into the Defense Federal Acquisition Regulation, the DFARS, or any of the other agency supplements. So in truth, like I said, the idea of a top 10 when you have hundreds and hundreds of clauses in your contract, all of which are important, I don't want to say just worry about these and ignore everything else, but I do want to basically kind of start with the idea that we should worry about these especially. And because I think that especially if some of these are new to you, they can really have significant impacts as far as how your contract administration goes. All right. So bucket number one, the administrative, I want to talk about the termination for convenience clause. I want to talk about the changes clause. And then I want to talk about the disputes clause. And if you've been doing this for a while, you'll understand that these are kind of old hat. These are old, reliable. These are oldies, right? These are like the Elvis or the Beatles tunes that everybody's going to love, right? But in truth, they're here because they have the potential to disrupt how you do your business. And most especially, this is going to be a theme as we look through the three of those clauses. If you're a prime contractor, you have the potential of being caught in the middle between your government customer and your suppliers there. So those administrative clauses, those are the three. On supply chain, I want to talk about some foreign sourcing restrictions, specifically some of the anti-Chinese through like Huawei and ZTE, and also anti-Russia concerns. And then we'll also talk a little bit about the TikTok ban, and then one of the newer FAR clauses that companies are still trying to grapple with a little bit are these FASC exclusion orders. FASC is the Federal Acquisition Supply Chain, Federal Acquisition Supply Chain Security Council, I forget exactly, but FASC works there. It basically is setting up a regime through which the government can unilaterally debar or exclude certain suppliers or certain products from its supply chain. With regard to compliance, we'll talk about issues related to cost or pricing data. We'll talk about some cybersecurity issues, talk about the overarching obligation to certify a whole bunch of things, and then we'll close out with talking about number 10 here, code of business ethics, which carry with it often an obligation to make a mandatory disclosure to tell on yourself if it ends up that you've done something wrong. So that's our overview of where we're going to go through. Like I said, if you have questions, type them in, and we'll catch those up on the back end. But let's jump in on number one, the termination for convenience clause. This is sometimes abbreviated as a T4C, and they were doing that before all the kids nowadays were texting, right? But this is a great text phrase, T4C. Okay, why should you care about this clause? The basic answer is because doing business with the government is not the same as doing business with normal commercial companies. The government can terminate its contract whenever it likes for whatever reason. And your ability to recover on any investments that you might have made up on the front end will be limited. They're going to be limited by the specific clause on that. Now, when I say for whatever reason, there is one slight limitation on this, which is to say the government can't terminate in bad faith, right? So if they're going out and they're trying to be malicious and they're trying to get back at Dave Gallacher Contracting Inc. because for whatever reason they feel like I've done them wrong, okay, there can't be bad faith built into this because every contract carries with it an implied duty of good faith and fair dealing. But with that being said, it doesn't take an awful lot to kind of paper over and come up with some kind of a non-bad faith type explanation. Well, we just didn't need that anymore. Or, well, we ran out of money, right? I mean, there are a lot of very simple, neutral explanations that the government can invoke that will typically satisfy the termination for convenience requirement on that. And so as long as the government says, we just don't want this contract anymore, that's a good enough reason to terminate it. So anyway, let's unpack that a little bit. There's various flavors here of the termination for convenience clause, and I've listed the predominant ones. But there's a T for C clause for fixed price contracts that are under the simplified acquisition threshold. That's the 249-1. The probably most common that's out there that I've dealt with the most in my career is 249-2, which is termination for convenience on fixed price contracts that are greater than $250,000. There's variations on that. There's alternates for whether it's products or whether it's services, dismantling, demolition, the services short form, educational institutions, cost reimbursements. So depending on what your type of business is that you're doing with the government, you may very well have one of these variations on this. But fundamentally, one of these clauses is going to be in every single one of your contracts. Now, if you do non-commercial work, those are the clauses. If you have a commercial contract that's been awarded under FAR Part 12, it's a slightly different variation on the clause, and I want to unpack and compare the two just so you know. But that's going to be listed at FAR 52-212-4L that sets forth the government's termination for convenience rights. But most importantly, every single contract is going to have some kind of a termination for convenience. Even if it's not in there, it's going to be implied as a matter of law. There's a case that goes back to the 1960s where the termination for convenience clause was removed, and the courts basically held, no, even though it was redlined out, termination for convenience is very important so that the sovereign United States of America, as it's awarding and administering its contracts, that it can do pretty much whatever it wants. And that's often that case going in the 1960s is called the Christian doctrine, and it dealt specifically for termination for convenience. Okay, so let me look. I want to unpack just these two so we can look at the termination for convenience, the longer form clause, and then the standard commercial clause that we have in 52-212-4L. So using 249-2 as an example, what this clause basically requires, or what it allows, paragraph A says that the government can terminate in whole or in part when it is in the government's interest. And that's a pretty low bar to meet, because whatever the government's interest is whatever the government's interest is. The clause sets forth the procedure that should happen. Basically, the government will give notice to the contractor to stop work. The contractor then is directed to actually stop work, to terminate all subcontracts, which means you need to make sure you're flowing down some kind of termination for convenience if in fact the government terminates the prime contract for convenience. And there's also an instruction there to settle all liabilities, to kind of package this up so that you can then submit whatever termination claim you have to the government. If there's inventory that's been assembled through the course of performance here, you need to submit those inventory schedules to the government within 120 days. And then ultimately submit a termination settlement proposal within 1 year. So this could stretch out a little bit here. The contracting officer has the authority to settle termination claims, but he or she will ultimately review that termination settlement proposal and determine whether or not your proposal adequately justifies and explains the costs to which you are claiming entitlement. Paragraph G outlines the categories of recoverable costs, and H and I also talk about some of the descriptions of the allowable versus unallowable costs that the government are willing to consider. The clause makes clear that there is a right to appeal if you're not happy with what the government is. And well, but that will be a formal dispute, and we'll look at that disputes process here in just a minute here, because it's not immediate. At the end of the day, the government gets to make the decision, and then your remedy is to basically appeal that decision. K, L, and M, paragraphs K, L, and M lay out the government's ability to settle, to make any equitable adjustments to the contract, and to issue any final or partial payments. And then finally, there is an instruction, therefore, that the contractor should retain documents relating to the termination proposal for up to 3 years, and the government retains the right to inspect records. So it's a long clause. And there's as we saw before, 249-1, for instance, is a short form, but FAR Part 49 actually lays out a lot of these policies in it, and it gives the government broad flexibility to terminate for pretty much whatever reason it wants when it's in the government's interest, and for you to later file a proposal or some sort of settlement proposal to seek additional costs. The commercial version of this clause, I've tried to put some highlight on here so that we can read, and maybe that works, maybe it doesn't, but it is essentially the same principles, just simplified. The government reserves the right to terminate this contract or any part hereof for its sole convenience. The instruction is to stop all work, subcontractors to cease work. Contractors will be paid a percentage of the contract price plus reasonable charges that the contractor can demonstrate to the satisfaction of the government using its standard record-keeping system that have resulted from the termination. The inertia on this favors the government because you have to satisfy the government. And again, if you don't satisfy them, they will make a decision that you have the right to appeal, but that will take time and money on this. Now, importantly, the clause says that this doesn't require specific cost accounting standards or specific processes, but it does require some kind of system that you, the contractor, are using that can generate reliable results, or more particularly results, costs, conclusions that the government can conclude are reasonably reliable there. The contractor shall not be paid for any work performed or costs incurred which reasonably could have been avoided. So this is not a function of the government sent you the stop work notice and you're like, oh, crikey, we got to cash this out. We need to try to get everything done right now so that we can maximize that recovery. I was expecting 5 years of income on this. Instead, they're terminating it after 2. That is only going to get you in trouble there on that. So, all right. Well, here's the bottom line for the termination for convenience clause to my view. And it's important because even if you have a 5-year or a 10-year contract, your contract performance and the money under that contract is not guaranteed. The government can come along and terminate it at any time for whatever reason. You may be the best student in the class. You may have the best performance. The government can still come along and terminate it, and there's not a lot that you can do about that. You will need to prove up to claim additional termination costs, and that proof could be extensive. I have regularly seen this when clients put in settlement proposals there where the government is constantly asking for more and more questions. And sometimes I see it maybe as a little bit of a negotiation tactic to try to get the contractor to settle for 70 cents on the dollar, 50 cents on the dollar to avoid just the headache and the hassle of this ongoing audit. But sometimes these reviews and these requests for additional documentation are legitimate because the government is just trying to understand the nature of the costs to make sure that it's fair and reasonable. Importantly, if you're the prime, you can easily be caught in the middle between the government and the subcontractors if you're not careful. So a good best practice on this is make sure that you are flowing down some kind of a termination for convenience requirement. Now, that may mean you're flowing down the clause itself, but more commonly what I see is just in a prime contractor's standard terms and conditions, there's a provision in there for termination for default and another for termination for convenience. But you want to make sure that if in fact the government terminates the prime, that you have the flexibility to terminate or to issue stop work orders to those subs before they incur all kinds of extra additional costs that they're going to claim against the prime, but that you can't claim against the government. So that's why you should be careful on termination for convenience. All right. Any questions on termination for convenience? Drop them into the questions panel. But let me move on to clause number 2 here that I'm thinking about. Clause number 2 is the changes clause. And basically what this clause does is it gives the government the right to change your contract. Not necessarily full blown and say we were previously buying balloons and now we're going to be buying a battleship. It doesn't necessarily go that far, but it does give the government significant flexibility to modify the contract as it chooses. So why should you care? Because the government can, oftentimes unilaterally, but not always, but I'll come back to that in a minute, but the government can change the contract requirements and force the contractor to perform, subject to an adjustment to the contract price. So the idea that the government is asking you for additional work, you don't have the option to say, no, I'm not. That's extra work. I refuse. The government will force you to do it, and any questions about it is a dispute. Now, you may say, but I don't want to get started on that. I want to negotiate a price first because I've got all the leverage in the first case. And you're right to think that. But the way the clause is written is the government will give the order. You have to proceed, and your remedy is to get paid later on down the line. And presumably that gets you actually more certainty as far as actual costs incurred, but it also means that the government has really the leverage, and your costs later on, you don't have the government over a barrel there in that moment. They've got you over the barrel. Okay, so I've got listed here some of the main changes clause that we see. 52243-1 is probably the most common that you see in fixed price contracts. And again, it allows the government to unilaterally change the contract whenever it wants, within scope, but with your remedy being, well, you get to get extra dollars later on down the line once you've proven those up, once you've submitted proposals and the government agrees that that's fair and reasonable. Now, I put unilaterally question mark on this because importantly, under the standard commercial clause, the 52212-4C, the changes clause, in a commercial contract for commercial products or commercial services, the government does not have a unilateral right. All changes must be bilaterally agreed upon. So under these non-commercial clauses, the government can make unilateral changes and you have to respond. Under these commercial clauses, 212-4, the parties have to bilaterally agree on that. Now, what I think often happens is, because we live in a world where the government gets to do what it wants, right? Especially in the government contracting world, for better or for worse. The government on these commercial contracts will say, I want this extra change. And then the contractor will then come through and negotiate some kind of a solution on that. But it's an important point, I think, that sometimes people miss. They think that the government can unilaterally change the contract whenever it wants. And that's true for non-commercial contracts, but it's not true for commercial contracts that are governed by 52212-4C. So let's look at this clause here real quick. 243-1 changes fixed price. Paragraph A basically sets forth the fact that the contracting officer has the authority to order a change. It sets forth the contractor's remedies, which is to say an equitable adjustment to price, to schedule, or to both. There needs to be, to the extent the contractor believes that there has been a change in expectations, new requirements added, there needs to be timely notice of change to the contracting officer, and the clause specifically notes 30 days, that you need to notify the contracting officer within 30 days that this is going to cost extra money. The idea behind that as a practical matter is it gives the government the chance to assess whether or not this is really important, whether they really need to worry about this. But that timely notice is critical. Paragraph D, it provides instructions for the proposals, and if there's any obsolete property that comes out of the specifically a deductive change, how you go about liquidating that. Importantly, any disagreements as to the change, any disagreement as to even whether or not it's an in-scope change, or whether it's bilaterally required. Those are all going to be disputes under the contract, which we'll look at here in just a minute, where again the government has significant flexibility. Now there's an alternate clause here for 243-1 that includes a paragraph F, and it's a good reminder, because even if it's not expressly in the clause, it's still going to be, the courts will typically apply this as a matter of law, and that is to say that only the contracting officer has the authority to order the change. So the alternate with paragraph F specifically reminds you of that fact. But remember, only the contracting officer who has authority to bind the government and to change the contract, only he or she can order a change. Your contracting officer's technical representative, your government program manager, if they are not the contracting officer, they cannot order the extra work. And again, even if you don't have this alternate clause with paragraph F in there, it's a legal requirement that the courts and the boards of contract appeals will typically impose one way or the other. Now, I mentioned there's a difference here, and this is, again, this is a little bit different from termination for convenience, where you have functionally the same right, whether it's commercial or non-commercial. But here, the changes clause is much shorter. Changes in the terms and conditions of this contract may be made only by written agreement of the parties. So that is bilateral obligation there on that. And that comes as news to folks sometimes, because we're used to thinking that the government has the unilateral right, and they do in the non-commercial space. But if you have a contract for commercial products or commercial services, bilateral rights. Okay, what's our bottom line on this clause? The government's rights are very different. The government's rights to order changes to the contract are very different in commercial versus non-commercial contracts. But nonetheless, what I typically see in commercial contracts, when the government orders changes or makes a change to the contract, the contractor will usually come in and just be very amenable to negotiate a solution, because it wants to keep the customer happy. Nonetheless, bilateral changes only for commercial contracts. There is a duty to proceed under the clause, even if there is a dispute as to whether the change is authorized. So that means the government has the leverage. You have to move forward on this, even if you disagree with it. They say, well, this is work. This is our interpretation of the specification, and you have to do X, Y, and Z. And you say, well, it's an ambiguous specification, and we've met it by doing A, B, and C. X, Y, and Z are not required. Your remedy here is or you're forced to proceed with doing X, Y, and Z, and your remedy is to later potentially seek extra payment through the claims and disputes process, which we'll look at here in just a minute. But the government has significant flexibility of making sure that whatever it wants and needs, that change is effected, subject to you later asking for more money. Timely notice and authority to order the change are key to recovery. If you have not demonstrated that if you fail to demonstrate that you didn't give timely notice to the government that there was going to be a change with a cost or schedule impact, or if it's ordered by somebody who does not have the authority, there is a very good chance you are not going to get any money back on that. So so a good best practice is change management. Make sure you are letting the contracting officer know and asking the contracting officer for direction when it comes to something that you view as a change to the contract requirement. As with T4Cs, you can easily be caught in the middle between the government and the subcontractors if you're not careful. So if the government has the right to unilaterally order a change, but you have not included that kind of clause in your subcontracts, you may very well say, okay, government has ordered me to do this, and I have a duty to proceed. Subcontractor now digs in its heels and says, no, I want to negotiate, right? You're caught in the middle there on that. So a good best practice here for prime contractors is make sure you have some kind of a changes clause built into your subcontract. And again, whether it's an express flow down or whether it's just in the standard terms and conditions. That's a good best practice, because the government gets to do what it wants most of the time, but private companies like you and me, not always. All right. Clause number 3 I want to talk about, the disputes clause. I've alluded to this a little bit as to if you don't like what the government's done on a termination for convenience, or if you don't like what the government's done under a change, what do you do? How can you push back and fight back on that? And the answer is, well, there's a process, but the process generally favors the government. All contractors are required to go through a fairly elaborate administrative process to resolve disputes, and the process heavily favors the government, especially in terms of time and money. Now, the standard clause that you have here for non-commercial contracts is 233-1, and for commercial contracts, it's 52212-4D. But guess what? These are actually essentially the same. So let's look at that. Let's look at what this is. Paragraph A basically says that this contract is subject to the Contract Disputes Act. And what that means is, and frankly, all procurements, or I think nearly all procurement contracts, are going to be subject to the CDA. And what it means is if you don't like what the contracting officer has done, you do have a right to appeal to a third party neutral outside of the agency. And that is either the boards of contract appeals, typically within 90 days, or the U.S. Court of Federal Claims within 1 year. Now, there are various boards of contract appeals. The Department of Defense has the Armed Services Board of Contract Appeals, the ASBCA. Most civilian agencies have a Board of Contract Appeals titled the Civilian Board of Contract Appeals. The Government Accountability Office handles contract appeals for the legislative branch. That's the GAO Contract Appeals Board. There is, I think the Postal Service has its own separate appeals board, and the FAA is a little bit different. They have they have an appeals process too that operates a little bit separately out of that. And these are administrative judges that are specialized in hearing contract appeals. And it's a great forum, provided that's the forum you want to go through. But the Contract Disputes Act basically lays out two remedies here. You can appeal a contracting officer's decision to a Board of Contract Appeals or to the U.S. Court of Federal Claims. Importantly, paragraph B says all disputes are resolved under this clause. All disputes. Even if you have a dispute as to whether or not something is a dispute, it's going to be resolved under this clause. Paragraphs C and D basically say that, look, you can file a claim for anything, a claim for money, a claim for a contract interpretation, or some kind of other relief from the contracting officer. But it must be submitted within writing within 6 years of the accrual of that claim. And if it's a claim for money, then claims valued over $100,000 must be certified. If it's merely a claim for contract interpretation, not for money, then you don't necessarily have to certify that. But importantly, you do need to specify a specific sum certain associated with your money claim, if that's what you have. Paragraphs E and F talk about the government's response, its process through which how it responds. Generally speaking, they are required to respond to your written claim, probably certified claim, within 60 days. But the clause also recognizes that a longer time period may be appropriate depending on how much factual investigation is required, depending on what the workload for the contracting officer looks like. The idea that they don't get more time is generally, like, the boards and the courts are generally pretty flexible, recognizing that the government needs as long as it needs to effectively respond to a claim. But that's not unlimited. That's not unlimited. But it does mean that the government does have some flexibility here to stretch this process out further than you or I might otherwise like. But the key point on this is that the contracting officer will issue a contracting officer's final decision, a COFD, as it's often abbreviated. And that COFD is key to either the boards or the court having jurisdiction over your appeal, because if you don't have a final decision that is being appealed, then the courts or the boards don't know what to do with it. Paragraph G makes clear that alternative dispute resolution may be available. Interest is due from the date of the claim if the decision is eventually reversed. So there is CDA interest available on these claims. And then, as I've alluded to earlier, paragraph I, and important to remember, there is a duty to proceed pending the resolution of the dispute. Well, the commercial clause on this, 212-4D, basically specifically incorporates FAR 52-233-1. So when I said they're essentially the same, that's exactly what I meant, is because they reference each other. So it says this contract is subject to the Contract Disputes Act, and failure of the parties to this contract to reach agreement on any request for equitable adjustment, any claim, anything is going to be treated as a dispute, and the contractor shall proceed diligently. So 212-4D, in addition to incorporating 233-1 expressly, hits the same high notes there as far as the duty to proceed, as far as the disputes process, and invoking the Contract Disputes Act. Okay, so here's the bottom line on this clause as to why I think it's important. One, keep in mind that it's essentially the same process whether you're a commercial or a non-commercial contractor. It doesn't really matter. Every company that does business with the government under a procurement contract is going to go through this CDA process, the Contract Disputes Act. Remember, you have a duty to proceed, even if there's a dispute as to whether the contracting officer's final decision is correct. Your solution is not to dig in and say, no, I'm not going to move forward until we reach resolution on this. You actually, at that point, if that's what you do, you might be in breach of your contract. You might be at risk of default. So let's just kind of be aware of what the government can do and what we can do, and not necessarily bite off more trouble than we need to. This disputes process, the time and money favor the government. It's going to take time. The government, again, can spread this out, and you, in order to get a neutral observer beyond the contracting officer at either the board or the court, to get a judge to rule on this, that's going to take time for you to formally appeal this, to formally prosecute those appeals, to possibly even have a trial on the issues there. All the while, the government has you under your duty to proceed. Now, if it's a money claim, you may get interest back to the time of your original monetary claim. So that's good, but nonetheless, the process still favors the government. Appeals can be costly, although there are alternative dispute resolutions that the government, as I said, tries to make available to try to streamline this. And there you go. Sometimes those are successful, sometimes not. Again, as with the last two that we saw of termination for convenience and changes, you can easily be caught in the middle between the government and the subcontractor if you are not careful. You may very well have a dispute with your sub. They want money from you, and you realize that that money is going to be done from the government. But if you have not built in a dispute process through which the issue is resolved first with the government, you may find yourself under an obligation to pay the contractor now before the dispute with the government is settled. So this is an important point, again, to either flow down directly, which I don't necessarily recommend because this is setting rights up vis-a-vis the government, right? The subcontractor doesn't have a right to appeal to the boards or to the U.S. Court of Federal Claims. So if you do flow it down, you want to make sure that you are modifying the parties to make sure that it's clear as to what they have to do. But I think most companies make clear that it is invoking or recognizing the government disputes process, and that the prime sub disputes process is largely going to mirror that. All right. Well, let me move on to my second bucket here, which is supply chain related issues here. And this foreign sourcing restrictions, it's a little bit of a cheat here. I've actually mashed two different clauses together here. But they're important, and especially because it's a little bit of a harbinger of things to come. You should care about these foreign sourcing restrictions because for every government procurement contract, and often even non-procurement contracts, you, contractor, are going to be prohibited from delivering and even sometimes using software or supplies from certain vendors that pose national security risks. Now, right now, those national security risks seem to be coming from Russia and China. And those are the two main clauses that we have right now, is they're addressing a Russian supply chain problem and a Chinese supply chain problem. But it doesn't have to be limited to those. The government, these are relatively new over the last 5 or 6 years, but the government's gotten a little bit of a taste on this. And I think that we'll probably be seeing more and more of these, as we'll see, especially when we get into the FASC exclusion orders. Okay, so we have here the 52204-23 relating to Kaspersky Labs out of Russia, and then the -24, -25, and -26 relating to some of the Chinese telecommunications equipment here. So let me just run through what these require generally. There's multiple clauses here. -24 and -26 are representation and certification language. -25 is the main one that deals with the prohibition on certain Chinese origin telecommunications equipment. This is sometimes called Section 889 because that's the section of the National Defense Authorization Act that it came out of. But many people, I think, just call it the anti-Huawei, anti-ZTE. This is the government basically concerned that there are back doors through some of this Chinese origin hardware and software on that gives the Chinese government potentially the ability to piggyback in and compromise our national security. Now, Huawei and ZTE are broadly prohibited under this, but it's not limited to just them. There are 3 other companies that are talked about as well as, and in slightly limited circumstance because it just under the clause. Huawei and ZTE are kind of across the board, but these other 3, Hytera Communications Corp, Hangzhou Hikvision Digital Technology Company, and Dahua Tech Company, as well as any subsidiaries of that. Those are the 5 companies, and they're all listed there in 52204-25. This applies to all prime contracts, all subcontracts. It prohibits, generally speaking, you providing this to the government, and it also includes a broad prohibition on any company using this, not even necessarily using it in connection with a government contract. It just says you shouldn't use it at all. Now, this is more broadly applied, I think, that it really needs to be as you look at the clause, because it's actually not supposed to flow down, but you're still certified to this in SAM.gov. And so anyway, generally speaking, though, I think the best way to look at 204-25 is you should not be providing or using anything from Huawei, ZTE, or from the other 3 companies, Hytera, Hikvision, or Dahua. Now, the Russian restriction here, this actually goes back a little bit longer on this. And there's an interesting story for Kaspersky Labs. But this basically says that you should not provide or use any Kaspersky malware software. And the great irony of this is that Kaspersky malware software might actually be malware, but I'll leave that to people who know better than this. But there you go. Now, this Kaspersky restriction relates specifically to government procurements. You might have read in the news recently there is a more recent ban that the U.S. Department of Commerce issued back this last summer in July, where it basically prohibited all Kaspersky entities from doing business or from selling any Kaspersky products in the U.S. market. They were added to the U.S. Department of Commerce's entity list, and this essentially was a big, huge blackball. And part of the concern on this is that it's a Russian-owned, Russian-sponsored software company. Can this create backdoors that create national security risks? Yes. So Kaspersky is increasingly becoming persona non grata inside the United States, and if you have any of this software, please avoid it. It doesn't do you any good on this. But the bottom line on these 2 clauses here, and why I've bundled them together here, is one, this is going to apply whether you're a commercial or a non-commercial contractor. It's the same way. In fact, it's a mandatory flow down in commercial subcontracts. So the government's vision on this is that it's going to go through, and I just realized my camera turned off. Sorry about that. I'm back. Sorry about that. It's going to be, you want to make sure that you're flowing this down into your supply chain. It requires diligence into your supply chain and also into your suppliers, because you might need to know not only am I buying from Huawei or ZTE or Kaspersky, but are my suppliers flowing something up to me through the supply chain? And a lot of times the way that that's kind of manifested as far as the compliance is through certifications and promises and representations. But it does require some additional due diligence into your supply chain. There are significant costs and consequences if you fail to comply. So please, please be careful. All right, let's look at number 5 here. 5 is a little bit of a variation on this same thing of continuing the theme of anti-China. I put it in here mainly because it's new. It's about a year plus old. It came out summer of 2023, but this is the TikTok ban. And this also is maybe a little important because it reaches into the supply chain, but also because it continues to be a little bit of a moving target. Why should you care about the TikTok ban at 52204-27? Well, the answer is because you are prohibited from having TikTok installed on any government system and on any IT product that is used by a contractor to perform on a government contract. Okay, that makes sense. I shouldn't have TikTok on my government contract. But here's the question. What about my phone, right? My personal phone, can I have TikTok installed on that when I'm doing government work? That's the more complicated question, and I don't have a perfect answer for that. Essentially, I think the answer is yes, provided it's not compromising the government systems. But I think most companies that are grappling with this are saying, look, you got your personal phone and you got your work phone, and never the twain shall meet. And so let's just make sure that we keep those separate on that. There's a reference here to the TikTok clause. Importantly, it references ByteDance, which is the parent company. So it doesn't actually specifically say TikTok on that. And so sometimes people are like, wait, I don't see the TikTok clause. It's the ByteDance clause as well. And then I've also included here this QR code to the Office of Management and Budget Memorandum that talks about how the government is going through and trying to implement this and getting you a little bit closer to some of those kind of dual use devices where it's my personal phone, but it might also be doing work on government. There's some guidance that's offered there for that. Okay, now the interesting thing about TikTok is, so this came out, as I said, in summer of 2023. But this is a moving target because many of you might have read in the news in April of 2024, President Biden signed the Protecting Americans from Foreign Adversary Controlled Applications Act. Oh, these always have the worst names, right? But essentially, it's the idea behind it is that they gave ByteDance the ultimatum saying, you sell by January 2025, or we are going to kick you out of the market. So we're still a few months off on that. We've got, I guess we've got about 90 plus days. ByteDance, TikTok has said that they're not going to do that. So we may very well, they're trying to fight it in the courts. They're not going to succeed, I think. This actually was most recently, just last month in September, the U.S. Court of Appeals for the D.C. Circuit here in Washington, D.C. heard appeals on this, on the challenges. And at the end of the day, I don't know, government favors government. And I don't say that to be kind of conspiratorial, but just to recognize that's where the inertia goes on this. But we'll see if the TikTok ban goes more broadly across the country. But right now, this is limited to just procurement contracts. Here's the bottom line on the TikTok ban. Essentially the same process, same clause for commercial versus non-commercial contracts. This is one of the themes on the supply chain. The government likes buying commercial because it's simpler, it's faster, it's maybe cheaper. But at the end of the day, they're starting to impose a lot of these supply chain restrictions that you would normally see on maybe your traditional defense contractors to say, no, we just don't want any of this national security compromising tech in our supply chain whatsoever, whether it's commercial or non-commercial. Requires companies to manage access settings on every single device, every single network. TikTok should not be there. All of our teenage kids, they feel wounded. It's funny. This is like whenever I talk, my kids don't care what I do. as far as procurement law, because I'm like, yeah, that sounds boring. And then I'm like, oh, but I'm working on TikTok, and they're like, ooh, suddenly my daughters are very much interested in this. So it gives you a chance to be relevant. This does not apply to personal devices and phones, but it might if those personal devices are used to perform government work. And again, as I said before, there's a mandatory flow down on this. Okay, the last here relating to the supply chain, and this is frankly maybe a culmination of these things. It relates to the FASC exclusion orders. And you should care about this because there is a process through which if the government issues an exclusion order for a particular supplier or a particular product, then you are prohibited from delivering and probably also using that software or supplies that are deemed to pose national security risks. So I put this in here because this is new from just about 12 months ago, and we're still trying to figure out how this works. The good news is there haven't been any exclusion orders issued yet, so nobody has really had to kind of test how do we implement this. But the bad news is that it gives the government significant flexibility to basically stop you right here, right now from buying, and that can be very, very disruptive on this. There's 3 clauses associated with this. The -30 clause is the main one that you typically see. -29 is the standard certification language, and -28 relates to the federal supply schedule contracts, implementing essentially the same requirements. But what does this do? So the -29 certification requires you to do a reasonable inquiry when there is an exclusion order issued that you are not providing or using products or services if the product or service is subject to a FASC exclusion order. And the 204-30 clause, again, basically formalizes that obligation, requiring you to check on at least a quarterly basis. Where do you check? Well, you go to sam.gov, and which is the System for Award Management, and right there they have a tab where you can check on these supply chain security orders. And right now this is what you see, or rather as of yesterday. But this has been pretty much the same screen that we've seen for the last several months. There's the acronym of what FASC stands for. It's the Federal Acquisition Supply Chain, and the act that implemented this was the Security Act. So sometimes this is FASC or FASCSA. All these terrible acronyms. Okay, so the bottom line on FASCA is, again, as we saw with these other supply chain restrictions, it's the same process for commercial versus non-commercial contracts. All of these clauses, the Kaspersky, the Chinese origin telecommunications equipment, the anti-TikTok, the FASC exclusion orders, these are all mandatory flow downs through subcontracts to commercial and non-commercial contracts alike. The government wants this going as deep into the supply chain as possible. It requires diligence into your supply chain, and at the very least, quarterly SAM reviews. And I guess when the first one of these things is put up, it'll be covered in the press, and we'll all figure out what to do with it. But remember, as with some of these other supply chain issues, there are significant costs and consequences if you fail to comply. All right, well, let me run through here, I guess, this last bucket, which is the compliance issues that I want you to be thinking about. And yeah, when you have a contract with hundreds and hundreds and hundreds of clauses, you've already got a lot of compliance obligations on there, and they're all important. But these are 4 that I think I typically see companies trip over sometimes, and I want to make sure that you're aware of them because, well, there's consequences associated with that. First here, cost or pricing data. Why should you care? The government has the right to require, in some circumstances, certified cost or pricing data to back up the price that you are that you're bidding to the government and that they're going to be awarding to you. The government has the potential, based on whatever information you're submitting, to try to negotiate and get that price down. Now, the government also, if they're not asking for certified cost or pricing data, they might also have the ability to ask for other than certified cost or pricing data, which is a very ubiquitous and broad category of any other information. And so the government has a lot of flexibility to to audit, to scrutinize, to ask you to justify and to explain why the price that you are ultimately offering to the government is fair and reasonable to the government. This is typically applying at the prime contract level, but the policies apply equally clearly at the subcontract level as well, where the prime contractor is spending these federal dollars. And so typically speaking, you'll want to make sure that you're flowing these down. I've got a chart here again with some of the main clauses that you'll see. Oftentimes these clauses come in with a little bit of a trap door, which is to say, if you have submitted defective cost or pricing data, or if the information that you provided was incorrect, the government has the right to retroactively claw back some kind of a price adjustment on this. So that's one thing to be aware of, because that could be serious, not only in terms of the price, but also in terms of a potential false certification, which you would always like to try to avoid. Certified cost or pricing data is generally prohibited under contracts for commercial products and commercial services. But as I stated earlier, the government may still require other than certified cost or pricing data, which gives them a lot of flexibility. Now, typically, the other than certified cost or pricing data can be satisfied through doing price comparisons without delving into a cost buildup, or more commonly through full and open competition. Such that, okay, we don't need to scrutinize exactly how my price was built up because I was competing against 4 other companies and we were all in the same ballpark. So the government's going to say, okay, that seems that this is fair and reasonable without additional scrutiny. But if you don't have all the circumstances satisfied in FAR 15.4, then the government may very well still have additional flexibility and the ability to reach in and require more from you. So here's bottom line on cost or pricing data. It creates additional audit and potentially, if you're providing certified cost or pricing data, potential false certification risk. And anytime you falsely certify something to the government, even if it's an oops, I made a mistake and it turned out to be wrong, that's still not exactly the day that I'm hoping you will have. Now, non-commercial, non-competitive contracts over $2 million will typically require certified cost or pricing data. So that's an important thing to keep in mind, especially if you're living in that space. And then, as I said earlier, there are a lot of exceptions as to when certified cost or pricing data won't be required. But even then, commercial competitive contracts will still require some form of other than certified cost or pricing data. And whether that's kind of market-based, comparisons, or competitive, that's great. But if you don't have that, the government may need you to crack open that price a little bit and look at some kind of cost or pricing data to figure out if your price is fair and reasonable. The government has substantial, but not unlimited, but still substantial discretion when scrutinizing your prices and when negotiating the contracts. All right, cybersecurity. Well, this is big, right? This is something that the government is worried a lot about, and they're making industry worry a lot about it. And so why should you care about these various cybersecurity clauses? Because the government requires, at the very least, basic cybersecurity precautions throughout the supply chain. And if you're a DoD contractor, there's a pretty good chance there's heightened requirements that apply to you. Well, here's a list of some of the main clauses here. I want to draw your attention primarily to the 52204-21, which is your standard FAR clause, and which is included in, I think, just about every single procurement contract that I see. And it's a mandatory flow down, so it's included in most subcontracts as well. Or the DoD clause, which is 252-204-7012, safeguarding covered defense information and cyber incident reporting. This is the build out on this. So 204-21, the standard FAR clause, requires basic compliance, or requires compliance with 15 basic requirements. And most of these are industry standards. But nonetheless, you want to make sure that your systems and that your cybersecurity is up to snuff. So you should inspect this list of 15 things. But essentially, it's limited access to your network. It's authenticating users through password, usernames. It's protecting federal contract information that you might have access to, monitoring visitor access through your networks and facilities, and conducting corrective actions reviews. That's essentially it boiled down there. And all of those look and feel and smell and taste very industry standard. But it's worth checking because you want to be sure. You don't want to say, I'm compliant with cybersecurity, and it turns out that you weren't. The company SolarWinds learned that the hard way. Now, for the DFARS clause, 252.204-7012, this requires compliance with more than 100 separate requirements, including the NIST. This is the National Institute for Standards Technology. I think that's what they are. The NIST standard 800-171 that lays out what some of these heightened requirements are. And it applies specifically to this DFARS clause to protect covered defense information, CDI, and controlled unclassified information, CUI. And that's what the government is really concerned about right now, especially in the DoD space. Now, this is still coming out, the final clauses on this, but it might also require a CMMC certification. That is the Cybersecurity Maturity Model Certification. That's what CMMC stands for. And it's a program the DoD is rolling out to require, in some cases, an express certification from companies. And that essentially lines up with the 15 basic requirements for level 1. Companies can self-certify that. But levels 2 or 3 require third-party certification, including potentially DoD coming in and auditing your cybersecurity here. So this is something that it's a high-risk issue. It's a high-profile issue. I mentioned before the company SolarWinds. You may recall, especially if you work in the government space for a while here, back in 2019 and up through December 2020, the software provider SolarWinds was hacked, and this was a supply chain hack. It was inserted lower in down the line, and then it flowed up through the supply chain. And SolarWinds got a big black eye, and the government got really scared, and everybody got a lot more religion when it comes to cybersecurity on this. So there are significant costs and consequences if you fail to comply, including the reputational risk that SolarWinds has suffered. I mentioned this. It's a mandatory flow down. It requires diligence into your supply chain, and it is the same for commercial versus non-commercial contracts. If you have a breach, the DFARS clause, and frankly, maybe even unique clauses for your specific customer might also include a mandatory reporting requirement. Okay, almost to the end here, and then we're going to hit our questions here. So number 9 here deals with certifications. And frankly, there are so many certifications in the FAR and the DFARS. I couldn't even list them here. I've listed the main clauses here. 212-3, that's the main offeror representations and certifications for commercial products and commercial service providers. And then you also have what this clause at 52204-8 that are annual representations and certifications requiring annual reps and certs from people. And then I've put in the 52204-7, which requires companies to register for the System for Award Management, SAM.gov. And as part of that registration process, you are certifying lots and lots and lots of things. Okay, why do you care about all these certifications? Because you have to certify things to the government. And it's not so simple to say, like, yeah, well, whatever. Like, you falsely certify or you miscertify something to the government, that carries significant liability. Maybe it's reputational, maybe it's money, maybe you're at risk of being accused of a fraud, maybe you're going to get suspended and debarred. Gosh, maybe it's even criminal if you've specifically misled and tried to lie to the government. That's all really serious. Now, the government likes certifications because they feel that there's some meat to a promise. Rather than just saying, you shall do this thing, you're basically saying, yes, I shall do this thing, right? But this is really what the government likes doing, and it's risky for you. I see companies sometimes they're like, let me get my registration up in SAM real quick. Hang on here. And I'm like, whoa. Are you doing due diligence on those certifications? When people put together a proposal and they're responding to this and they're just going through checking boxes, whoa, are you doing due diligence on that? I don't want anybody falsely certifying anything to the government. We can and we need to be more careful on that. Well, the certification process is essentially the same for commercial versus non-commercial contracts. I say essentially because if you're registered in sam.gov, and all prime contractors are supposed to be, and the government certainly likes it when subcontractors are registered in there as well. So they really love it if everybody's in there. There's a lot of promises that just about everybody is making. Some of these things require diligence into your supply chain, including, as we saw before, with use of Chinese origin telecommunications equipment, Kaspersky, TikTok, FASCA, some of these other things. You need to be aware of this, and it is going to require some due diligence. Your certifications may be express or implied. I've seen companies say, oh, I'm just going to leave all that blank, and then I haven't said anything wrong. Well, there is legal authority that basically says if you've performed on the contract and one of those contract requirements was adherence to a particular certification requirement, that there is an implied certification. So leaving something blank, you're very clever that you thought of that, but that's not going to be good enough. And again, false certifications can carry civil and, in rare circumstances, criminal liability. So let's be aware of that. All right. Number 10, Code of Business Ethics Mandatory Disclosure. This is the 10th clause I wanted to highlight. Why should you care about this? Because most contractors are required to have a written code of business ethics and conduct tailored to your government business. Now, large businesses are also required to have a formal business ethics awareness and compliance program and also internal control systems, but let's focus on what everybody has to have. If you have a contract that's valued at more than $6 million and running longer than 120 days, you're covered by this clause at 52203-13, and you need to have a code of business ethics and conduct. But beyond that, you also must tattle on yourself if it turns out that you find that you've done something wrong. There is a requirement that you file a mandatory disclosure in 3 circumstances: crimes involving fraud, conflict of interest, or bribes and gratuities, violations of the False Claims Act, or significant overpayments. If you determine that you have credible evidence that any of those 3 things have happened, you are required to tattle on yourself. Basically, what you do is you report yourself to the contracting officer and the Office of Inspector General for the agency, and they will investigate. If you don't file one of those mandatory disclosures, the risk is that you may be suspended or debarred. If you don't have an ethics program, there's a chance you might be deemed non-responsible. So basically what the government wants to do is that we're telling on ourselves when we've done something wrong, but also that we are institutionalizing an ethical and compliance culture in each of our companies on this. This is a mandatory flow down to subcontractors, and it applies to commercial, non-commercial subcontracts exactly the same. This is what the government is always trying to achieve. Now, I've got a little bit of a runners up here. I won't spend more time on them. These are, I think, 5 other categories that if I was doing a longer list, if we had more time, I might also talk about country of origin, buy American, small business subcontracting issues, equal employment opportunities, service contracting, or even data rights and computer software. We don't have time. But keep in mind that if I was to expand this to 15, we'd be talking about these guys as well. All right. Well, we're coming up on the end here, so let's jump into our quiz. Joshua Lee, can you give us quiz number 1 here and do this? And I'm going to drink some water, and we'll go through this, and we'll explore 5 questions here, and then I'll turn to the questions that everybody else has chimed in on. So, Joshua Lee, over to you.
Sounds good. First question: which of the following is a valid reason for the U.S. government to terminate a contract for the government's convenience? T for C. A. The government does not need the product or service anymore. B. The contracting officer changed his or her mind. C. The agency's budget has changed and funds are not available. D. The contracting officer suspects the contractor of wrongdoing. Or E. All of the above. I'm going to go ahead and put that poll up. Make sure you guys submit your answer.
All right. What do you guys think? What is a reason that a valid reason that the government can terminate a contract for its convenience? Let's see here. Most of you are choosing E, all of the above. Okay, we've got a few that are saying A, the government does not need the product or service. 1 on the agency's budget has changed. Let's give it 5 more seconds. 4, 3, 2, 1. Joshua, let's end that poll here. Yeah, you guys are, most of you are right. It's answer E, all of the above. The government can terminate a contract in whole or in part if the contracting officer determines that a termination is in the government's interest. Everybody who answered A or C, you're not wrong. Those are good reasons, but it's not limited to just those. Short of the government acting in good faith, which incidentally gives rise to a separate claim that the government breached the implied duty of good faith and fair dealing, it doesn't necessarily mean that the government still can't terminate for its own convenience right here, right now. The government can terminate a contract for just about any reason whatsoever, as long as the termination is in the government's interest. And that's a pretty low bar for the government to demonstrate. This is an incredibly broad right that is implied in every single procurement contract with the U.S. government. All right, good job on that one. Joshua, number 2, how about this one?
Question number 2. What remedies are available to a contractor who disagrees with a contracting officer's final decision? A. Stopping work until the government and the contractor can reach a negotiated solution. B. Appealing the decision to a Board of Contract Appeals or the U.S. Court of Federal Claims. C. Appealing to the agency head for a secondary review. D. Suing the government in U.S. District Court. Or E. All of the above. I will put that poll up now and give you guys
All
a few
right,
minutes.
let's see what you think about this. Okay, we've got a few all of the aboves. All the above is always a good choice. We all remember that from when we were in college, right? The majority here coming in on number B. Well, sorry, letter B. It's not a number. Appealing to the agency head. Stopping work. Let's give it 5 more seconds. 5, 4, 3, 2, 1. All right. Yeah, the correct answer here is B, appealing the decision to a Board of Contract Appeals or the U.S. Court of Federal Claims. Now, to be clear on this, you could stop work, but that's going to carry collateral benefits. You don't have the right to stop work. And you could potentially appeal to an agency head for a secondary review, but that's not necessarily one of the remedies that are spelled out in the Contract Disputes Act. What the Contract Disputes Act specifically says, there's 2 separate fora to appeal the denial of a contract claim. The Boards of Contract Appeals, including the ASBCA, the CBCA, the Postal Service Board, GAO Board, and as I mentioned, the FAA ODRA, the Office of Dispute Resolution for Acquisition, and the U.S. Court of Federal Claims. U.S. district courts do not have jurisdiction over contract disputes. So to everyone who answered D on that, that is wrong. And that seems a little counterintuitive because, well, we regularly sue, right? But no, not here. And importantly, the contractor has a duty to proceed, and any work stoppage could subject the contractor to a claim for breach of contract. All right. Number 3, true or false? Joshua, could you put that poll up? The supply chain restrictions in the FAR generally prohibit purchases from any Russian or Chinese sources of supply. Is that true or false? Up on the screen, please. Or C, the answer depends on whether it's an election year, which is very cheeky. And, oh, we didn't even have that loaded in. What do you think on this? Give it a few more seconds. 5, 4, 3, 2, 1. We've got a split of decision on this. The answer is false. And here's why it's false. It's because it does not generally prohibit purchases from any Russian or Chinese sources or supply. What the FAR does is it targets to only specific vendors or individuals that may raise national security concerns. And as was mentioned right now, that is Huawei, it is ZTE, it is Kaspersky, it's Hikvision, it's Dahua, it's gosh, I forget the 5th one off the top of my head. But anyway, those are the specific named entities in this. Now, there's certainly a sense, especially during an election year, which is why I was a little cheeky there, that it's kind of all anti-China and anti-Russia, but that's not where the regulations go. Even installing, some of these are targeted to specific companies, but they are named, and these are companies that are raising specific national security concerns by the White House and Congress. So it's not generally, it's not broadly, it's much more targeted. And the FASC process is going to close that out too. So, all right. Number 4, true or false? A company can avoid making certifications to the United States government by leaving a FAR clause blank. Josh Lee, can you put this up for us? Is that true or is that false? What do you think? You guys were listening. You're so great. I see everybody chiming in false on this, and that's exactly right. We've got 100%. Let's close this one out. You guys got this. Oh, one true, and I think you did it just to annoy me. So, no, I'm just kidding. But yeah, the answer to this is even if a contractor does not expressly certify that it will comply with the certification requirement, a certification may nonetheless be implied through performance. Moreover, any company registered with through sam.gov is required to make dozens of separate representations and certifications, and you can't complete your registration without it. So the idea of leaving these things blank is a little bit naive. Last question, and we're at time, but we'll stick around and we'll answer questions. Number 5, which of the following is not listed as a reason that a company must file a written disclosure with the contracting officer and Office of Inspector General? Joshua Lee, if you could put that poll up. Is it A, the government made a significant overpayment? B, the contractor suspects that a competitor is overcharging the government? C, the contractor has credible evidence that certain crimes have committed involving fraud, conflict of interest, bribes, or gratuities? Is it D, that the contractor has credible evidence of a False Claims Act violation? Or E, none of the above? All of these are listed reasons. Let's see what you think. We'll give you a few more. Let's go 3, 2, 1. All right, let's close this out. The answer here is B. This is the one that is not listed in the regulations, that a competitor is overcharging the government. You may choose in your discretion to kind of tattle on the competitor, but that's not a reason that you are required to file a disclosure to the government. The 3 that are specifically listed in the suspension of debarment regulations are significant overpayment, credible evidence that certain crime has been committed, or credible evidence that there has been a False Claims Act violation. All right, well, we're at time, a little bit over. I apologize for that. Joshua, any parting words before we move into our final questions?
Sorry, Dave. You cut out for me for a second.
Yeah, I just, do you have anything to say? Or I'll tell you what, if anybody wants to drop off, you're welcome to. I realize we're at time, but let me get through our questions here and try to take these in a relatively efficient manner. Stephanie, she talking about the termination for convenience. She says, we have the T for C clause in our time and materials IDIQ agreement. Is it appropriate to use a partial T for C clause to release an individual subcontractor employee from performing services? You might be able to do that. In truth, the T for C clause does allow for partial or complete termination on that. You don't normally see, I think, like individual employment personal services, I think, that are governed by this. Usually, a lot of times that feels a little bit more like at-will employment, but I'm not an at-will employment attorney, so I will stop before I say something wrong on that. But look, bottom line is, if you have that T for C clause in and it gives you the flexibility to terminate, as long as it's in the government's interest, then you can absolutely do that. Daniel says, if you're a subcontractor, what would you say to a prime contractor who wants to flow down T for C clauses such that the prime could terminate the subcontract for any reason whatsoever? Daniel, it's a great question. I'll tell you what I say when I'm the subcontractor. I say, no, I don't like that clause. You, prime contractor, if you want to flow down a clause that says you could terminate me for convenience, when the government terminates you for convenience, that I'll agree to, because it keeps the prime from getting caught in the middle there. But there's no reason that a private company should have necessarily the unilateral right to terminate a contract. They're not the sovereign United States of America. So I typically push back on that. And I think that most companies are willing to agree to that as long as, again, they have the right to act when their prime contract is terminated, to act appropriately. So I regularly take that position when I represent subcontractors. When I represent prime contractors, I won't tell you what I say. Doesn't matter. James says, I'm managing the subcontract that's commercial under FAR Part 12, but in the flow downs, it didn't incorporate 52212-4 for changes, but rather used its own terms tailored for its needs that more closely resembles the clause under 243-1. Is that acceptable? If not, what should be done to correct it? Well, if you don't like it, you could maybe go through and bilaterally modify it. If you signed on to it, it's maybe something that you should have caught months ago when you originally signed the contract. But yeah, I won't say that it's right or wrong. It just is what it is. And oftentimes when we get into these negotiated contract clauses, if that's what you sign on to, there's, it's neither morally right or morally wrong. Is it a little bit taking advantage? Maybe. But oftentimes that's what contracts are, is people take advantage of each other. Mary says, what about claims related to data rights? Yes, claims relating to disputes about government data rights. I believe that those are subject to the disputes clause just the same. I think the data rights clauses actually have a unique process through which you can go through to initiate that. But nonetheless, any dispute with the government is going to be handled under the disputes clause. Terry says, have you heard of a prohibition on, quote, all products and services from Acronis or any subsidiary or affiliate? This prohibition was included in a recent government award. No, I have not heard of that. I've not heard of Acronis. I haven't heard of any of those things, and so I don't know where that comes from. But it tells me that that government customer has a reason why they're scared about that particular vendor. And if that's included in your individual award, look, maybe address it, explore it during the Q&A process. But if at the end of the day it's in your contract, I would say, well, that's something that becomes clause number 11 of the most important thing to worry about here, because you're going to need to comply. Michelle says, if I have a personal phone, this is relating to the TikTok ban. If I have a personal phone, but I do some work with it, such as responding to emails, Teams meetings, etc., is that okay? Meaning, can it still have TikTok on it? I think, Michelle, the answer is yes. I think that's okay. But it's still a thing here that's kind of emerging. Your company would still want to make sure that it has precautions, and certainly your big defense contractors have been uber cautious, and they've said, Gallacher, you have your personal phone, and then you have your work phone, and never the twain shall meet. And if companies are concerned, then there's, that could be a reasonable response. All right. David says, when certifying your certified claim, does the FAR-DFARS cover who should certify that all the facts as of the date of price agreement that prudent buyers and sellers would reasonably expect to affect price negotiations significantly have been disclosed? So this is relating to the cost or pricing data and providing certified cost or pricing data. I said certified claim earlier. I apologize for that. No, I don't know that it specifies exactly who that individual must be. I think that the only requirement in the clause is that it's somebody who has authority to certify on behalf of the company. David follows this up, says, does every BOE author, this is the basis of estimate, a person who's going through building into that, do they separately need to certify, or can a functional IPT lead or functional organizational lead sign off? I think that that latter makes sense. I don't know that it needs to go to every single person. Now, I think you would want some kind of verification, but at the end of the day, the certification is from one person at the company as they're providing all that certified cost or pricing data. Larry says, are the slides going to be available after the call? They're available right now. You can go up to the top tab there under materials, and you can download these things through. David Ribeiro says, wait, you're only required to register in SAM if you're a prime contractor, correct? The answer is Probably yes, but not necessarily. Meaning, if I've got that 204-7 clause or the 204-8 clause that's flowed down into my subcontract, technically I've agreed to register in SAM. I've seen the government that is actually really try to push everybody to register in SAM, including subcontractors, but there you go. Okay. Let's see here. Does the Contract Disputes Act apply to other transactions? I believe it does, Daniel, but I'm not positive on that. There's procurement contracts, there's cooperative agreements, and there are what are called other transaction agreements. I do believe that the CDA applies to OTAs. Maria asks a question. I'm not sure which clause you're referring to, but she says, are the companies named specifically in the clause itself? If you're referring to the Chinese telecommunications equipment, the answer is yes. They are. The 5 companies are specifically spelled out there. Huawei, ZTE, and the other 3. All right. Sabrina says, can a contractor still certify if the procurement contracting officer, the PCO, elects to agree on a price based on a prior proposal pricing without an RFP? No additional cost or pricing data was requested. I don't know the answer to your question, Sabrina. I'm sorry. That is, it's down in the weeds a little bit. I think that at the end of the day, what you want to make sure is that it's current, that it's complete, and that it's accurate. And whatever that is that you're certifying to, I think that's the best answer I can give you. Sorry, I'm not a I'm familiar with cost or pricing, but I'm not a cost or pricing guy. So, Christy says there are actual certs that a contractor is allowed to leave blank in cases of non-applicability, like information technology that's a commercial product, and that's true, Kirsty. But leaving something like, say, the telecommunications certification blank, that's not going to work. But there are some, for instance, in SAM, most companies basically on the Buy American Act or the Trade Agreements Act certification say, hey, it depends on what we're delivering on a particular contract. But saying I'm not going to certify anything, you do run the risk that by performing that you have an implied certification that you've complied. Kevin says, why are the foreign sourcing restrictions and the FASC exclusions separate clauses when they both have the same ultimate goal of prohibiting delivery and use for national security reasons? And the answer is because Congress is separately passing these through separate issues in the White House. So it's a little bit of an iterative process. I wouldn't be surprised if at the end of the day, years from now, they kind of collapse it into one process. But right now, the FAR as we have it is iterative. And it feels a little duplicative sometimes, but it is what it is. Let's see here. Michelle says, what are your thoughts around final orders related to the defense base, or excuse me, to the DBA, which I'm not sure what that refers to, Michelle, so I'm sorry. So my cheeky answer is I don't have any thoughts. And Susan says, Davis-Bacon Act. Sorry. What are your thoughts around the final order related to Davis-Bacon Act? I'm not familiar with that final order that's been issued, but look, service contracting and these wage determinations that you're required to give under these service contracts, really, really tricky. And they have the potential, especially as the Department of Labor updates these things, to kind of boomerang back and cause you increased costs. Now, the good news is that's a contract change and you'll get compensated for that. But the bad news is if you weren't paying accordingly in the first place, you might have non-compliance, you might have false certifications, lots and lots of troubles. Susan says, will there be a recording available? Joshua Lee, this will be our last one. Great questions, everybody. I appreciate it. I'm sorry we've run so far over. That's frankly my fault, but you guys are great questions. Joshua Lee, what about recording? What about slide availability?
A recording will be available by tomorrow, and the slides were sent out via email from Ophelia. You can also access these slides on your materials tab of your GoToWebinar window and through our website.
All right. Well, we've gone quite a bit over, and I'm sorry about that, but I thank you guys for your patience here. Larry, Michelle, you both say thanks. I thank you as well. Joshua, any final parting words before we let these people get back to their day job and just doing good, working with contract administration?
Yep, as always, we'd love to know how we did. All feedback is appreciate everyone's participation and your great questions. Make sure you guys check out PCI's website for our upcoming programs. We do hope to see you all again, and we thank you for joining us in our final GovCon 101 of 2024. Thanks, David.
Okay, thank you very much. Okay, have a good day, everybody.